You're on.
Hey, good morning, or rather good afternoon, everybody. This is David Monks. I'm with Fuller Law Group. I'm a proud member of the Poway Chamber of Commerce, and I thank the Chamber a lot to give me the opportunity to share this information with you today about the California Family Rights Act. My practice in law specializes in employment law for employers. And so issues like this, providing leaves to employees and how to handle them, is something I do all the time. And you'll learn why I think this particular course is really important. You know, I can predict that probably about halfway through our webinar today, you're going to be thinking to yourself, you know what, Monks, I was having a pretty good day till I started listening to you. This law is ridiculous. It's nuts. And I'll say to you, you know what, hang in there, because a few weeks, maybe a few months, maybe a few years from now, you're probably going to have to respond to one of your employees' requests for leave under the California Family Rights Act. And I think that you'll look back on this webinar as being very helpful to you at that point. So hang in there. There's a lot of information. It can be kind of overwhelming, but I'm going to give you some good resources to use after today. And I'm also going to have you take away some really good tips. So let's get going. I'm have the screen up here, and I'm going to start marching through. So the California Family Rights Act, like its federal counterpart, the Family Medical Leave Act, was passed in 1993. And for its first 27 years of life, it applied only to employers of 50 or more employees. But in the fall of 2020, the legislature here passed and Governor Newsom signed a bill, Senate Bill 1383, to modify the California Family Rights Act drastically. Now this law applies to employers of 5 or more employees. And we're going to talk a little bit more about that. It's a very, very drastic change. And that was effective January 1st of this year. The law overall applies to more employers and provides broader protections to employees. And here in California, I think you all would agree that's not terribly surprising. So let me start by giving you a couple of resources that I think will be really handy to you. One is the actual CFRA, right? The California Family Rights Act is located in California Government Code section 12945.2. And if you simply Google that, you'll get the statute, its language, and it's probably a really good resource to have. Perhaps an even better resource are the regulations that California, through the Department of Fair Employment and Housing, has implemented to put the CFRA into effect. These were recently modified to reflect the changes in SB 1383. So the way to find those regulations is to Google what I've said there, Code Regulations, California Family Rights Act, and you'll arrive at this website, govt.westlaw.com. And I gave you a little screenshot of what the first page is going to look like there. And you can click on any of those links to go to the various regulations that apply to the California Family Rights Act. They're really detailed, they're really helpful, and I think they're an essential resource for you anytime you have an employee who may have, be eligible for leave under the California Family Rights Act. So let's talk about what a covered employer is. And as I've mentioned, it's any employer that employs 5 or more persons within the United States, right? It's not just in California. You may have employees in different states. You have to count all of them in determining whether you meet that threshold of 5. Now, the benefits are only available to California employees, not to your employees in other states, but those employees in other states have to be counted to see if you reach that threshold. What does it mean to directly employ an employee for purposes of determining whether you get to that 5 mark? Well, it means that the employer maintains at least 5 part-time or full-time employees to perform services for a wage or salary as of the date on which the unlawful conduct occurred. And that means, guys, that the date on which either the plaintiff is claiming that your company retaliated against them, or the date on which you denied their request for CFRA leave and they're claiming that was their interference with their CFRA rights. So that's going to be the date that's going to be the focus in determining whether you were a qualified employer at that time. As I said before, the threshold is now 5. It used to be 50. It's a huge deal. There are tons of small clients that I've had, small clients that colleagues of mine have had, and even some mid-sized employers, depending on how you define what's mid-sized or not. But there are a gazillion businesses under 50 employees that now have to deal with this, and they've never had to do it before. And that's why I think this course is so important, because it really gives people an understanding of how important it is and gives them tips on compliance. Because if you don't comply, you're exposing yourself to some really substantial legal liability. Now, also for purposes of determining the threshold of 5, you look at employees who are on paid or unpaid leave, maybe a workers' comp leave or a disability leave of absence or something like that. Or even if they're on suspension or a pregnancy leave, they count. And so they're still on your payroll and they count toward that threshold of 5. Now, performing services for a wage or salary means under the regulations what you would think it means, someone who's a W-2 employee, right? Independent contractors don't count. Although, please be sure that you've classified workers correctly as independent contractors versus employees, right? If you don't have that right, those workers are going to be employees. Not only would they count toward the CFRA threshold, but you now have a whole new can of worms of misclassifying a worker as an independent contractor. That's a whole new webinar we'll do another day. It does also include people who are paid by commission, either in whole or in part. They count toward the 5 employees. What about joint employer situations? So I found that a lot of businesses aren't really sure what it means, what joint employment is. So the classic situation, there's 2 of them really. One is where your company is somehow affiliated with another company. Your company is a subsidiary or a parent of another company, or maybe you're a sister company. You and your company A and company B are sister companies of a larger company that's the parent. Their joint employment is probably pretty easy to see, meaning the employees of your sister or your subsidiary or your parent might have to be counted when it comes to deciding whether your particular company, which may only have 1 or 2 employees, actually has to consider yourself to have reached the threshold of 5. Another situation is where a company uses a staffing company or a temporary agency to get labor into their workforce, right? So let's say your company has 1 or 2 or 3 employees, but you contract with a staffing agency to have 2 or 3 or 4 or more companies do work for your business. It's very possible, if not likely, that those temp employees, if they otherwise meet the definition of employee under the regulations, are going to have to be counted. So that while you think you may have 1 or 2 or 3 employees and are under the 5 threshold, adding those temp employees in may push you over that threshold. So that's something you really have to look at and work with your employment law attorney to determine whether those temp employees can be excluded or whether they have to be included. All right, that's some basic stuff. Let's just give you an overall process of what you're going to have to do when you have a scenario where an employee has said they want leave, and it may be for a reason protected by the California Family Rights Act. You have to look at whether the employee is eligible. They meet the service requirement and the hours requirement. We're going to be talking about all this stuff. Whether they are seeking time off for a qualifying CFRA reason. Have you given the employee proper notice of their CFRA rights? You have to calculate how many CFRA leave hours they have available to them. Are they asking for intermittent leave, right? Not taking all 12 weeks at one time, but taking either a couple weeks at a time, or sometimes you have a situation where an employee says, I need every Friday afternoon off for medical treatment, right? 3 or 4 hours, and that needs to go on for a couple of months. That's intermittent. You have to respond to the CFRA request in a timely manner. You have to look at whether you need or want a certification by the employee's healthcare provider that they have a serious health condition, which is one of the qualifying reasons. You have to look at whether if the employee qualifies for CFRA leave and is eligible to take time off, you have to designate their time off as CFRA protected leave. You have to worry with pay issues and benefits issues, And you also have to consider whether or not you'll have to reinstate them. And I can tell you, in 99 times out of 100, you're going to have to reinstate them to their identical job or a comparable one. There are some exceptions, and we'll look at those. But when you designate leave as CFRA leave, you have to tell the employee that they have a right to be guaranteed to be reinstated to their job or a comparable job. And you also have to consider whether or not you're going to require or can require the employee to provide a medical release of returning to work from their healthcare provider. So we'll look at all these things. Let's start about employee eligibility. Again, it goes to full-time or part-time employees. One criteria is the service requirement. They have to have been employed with you for at least 12 months before the day when their CFRA leave is going to begin. Then you have the hours requirement. Have they worked in the 12 months before the start of that CFRA leave? Has the employee worked a minimum of 1,250 hours? That's not terribly hard to do, but it is a requirement. And if they meet that, then that checks the other box for eligibility. If they don't, then you can deny their request for CFRA leave on that basis. There's a couple rules to keep in mind, and these are discussed in more detail in the regulations. One is that if you have an employee who was with you before, left, and is now with you again, if there's a break in service of less than 7 years, then you don't really count that break, if you will. If there's a break in service and they worked with you more than 7 years ago, you don't count that previous service toward the 12 months or toward the hours requirement, except there are some exceptions where you have a written agreement to the contrary or where military service is involved. It's important to keep in mind that the employee can satisfy the 12-month service requirement even when they're on a leave of absence from you. Again, it could be a workers' compensation leave, it might be sick leave, it might be vacation or PTO. If they are not actively working for you for one of those reasons during that other 12-month period, that time not actively working for you still counts toward the 12-month service requirement. So if you've never dealt with the CFRA before, you might not have heard of this old rule, but in case you have, or just out of interest for those of you who have never had to deal with this before, the current Federal Family and Medical Leave Act and the prior version of the CFRA had this rule that says to be eligible, not only does the employee have to have the 12 months of service and the 1,250 hours of work in those 12 months preceding the leave, but they have to have worked at a work site with 50 employees within a 75-mile radius at the time that the leave is requested. So even for some larger employers with 50 or more employees, if they didn't have 50 or more within a 75-mile radius of where the plaintiff worked, the employee worked, then the provisions of the FMLA or the old CFRA would not apply. But Senate Bill 1383, effective January of this year, took that away from the CFRA. That is no longer a requirement. So if you're trying to figure out whether your employee is eligible, and one of your managers or an HR consultant or somebody else says, you know what, you got to check whether they're you have 50 employees within 75 miles, say, no, that's not the rule anymore. I was talking to my good friend David back on May 12, and he said it in case. So that's the rule. Don't use that in determining whether your employee is eligible or not. All right, let's start looking at the qualifying reasons for the leave. This is really where we get to the heart of the CFRA. There are 4 reasons, one of which is brand new. One is when your employee has a serious health condition, and we're going to look at that. This makes some people think about the Americans with Disabilities Act or its California counterpart, the Fair Employment and Housing Act, which also protects employees who have qualifying disabilities and medical conditions. But the definition of an ADA or Fair Employment and Housing Act disability for purposes of those laws is not identical to the definition of a serious health condition for purposes of the CFRA. It's very specific. And we'll talk about that in a little bit. Another reason employee might be entitled to take CFRA leave is to care for a qualifying family member who has a serious health condition. A third reason is what we call baby bonding, when your employee or his or her partner or spouse has a newborn baby, a newly adopted child, or a newly placed foster child. They call this baby bonding time. There's no serious health condition, there's no disability, there's no pregnancy involved. This is just, they have a baby through birth, foster placement, or adoption, and they are now entitled to take up to 12 weeks in a 12-month period to bond with their new baby. And now the new qualifying reason is what they call a qualifying exigency. I always have trouble saying that, so I say it really slow. This comes from the federal FMLA, which has protected the rights of military families and service members in the employment context for a long time. But now the CFRA has been amended to specifically provide unpaid time off for employees who have to, either because of their own service, a call to active duty, or a call to active duty for one of their qualifying family members, needs time off to take care of some of the very special or unique activities that military families have to deal with when someone in that family is deployed and called to active duty. And we're going to take a look at those in a little bit. So if any of those four is at issue here, then that is a qualifying reason for your employee to take CFRA leave. All right, we'll start talking first about serious health conditions. So the basic premise of this is that the employee has a medical condition that prevents them from being able to perform the essential functions of their position. The other aspect is when your employee wants to care for a family member who has a serious health condition. And here, the idea is that they need to care for a child, a parent, a grandparent, grandchild, sibling, spouse, or domestic partner who has a serious health condition. Under the old law, before January 1st of this year, an employee could take time off only to care for a child, parent, or spouse. As you can see, it's been significantly expanded. Child also includes adult children of the employee, even if they are not dependent the way you would normally think of on that employee, and also children of a domestic partner. So the scope of an employee's family members for whom an employee is entitled to take time off when that family member has, a serious health condition has been significantly broadened. So what is a serious health condition? This is probably the part of the webinar where you're going to be having those thoughts I talked to you earlier, where your head's just probably going to spin. And frankly, I removed a couple of frames here because they made my head spin. It would simply take too long to go through all this stuff. But this is where those regulations really come in handy. And it's where having a good relationship with an HR consultant, if you don't have an HR person in your own business, and a relationship with a good employment law attorney can really come in handy. So the regulations define, and the statute defines, a serious health condition as an illness, injury, impairment, or physical or mental condition that involves either what they call inpatient care in a hospital, hospice, or residential healthcare facility, or continuing treatment or supervision by a healthcare provider. So we're going to look at those a little bit. This includes treatment for substance abuse. It doesn't include less medical things or less chronic things like cosmetic surgery, colds, the flu, routine stomach aches, dental problems, things like that. Those don't qualify as serious health conditions that would justify CFRA leave. All right, so let's look at inpatient care. I'll tell you, this is, even for me, I have to read this several times every time it comes up. It's really dense, but I tried to keep it as simple as possible. Inpatient care is defined here. It means any one of these three things. a stay in a hospital, a hospice, or a residential healthcare facility. And that includes even a situation where the facility has admitted the employee with the expectation that the employee will remain overnight or longer and actually occupy a bed in that facility. But even if that doesn't happen, the employee can still qualify under this prong of inpatient care. It sounds absurd, but that's what the regulations say. Inpatient care also refers to any subsequent treatment that is related to or follows inpatient care. It's kind of a separate segment of qualifying basis. And a third basis or a third type of inpatient care is what they call any period of incapacity. And the word incapacity itself is defined in the regulations as I've written here in this slide. The inability to work, attend school, or perform other regular daily activities due to a serious health condition, due to its treatment, or due to the recovery that the health condition requires or that the treatment requires. So it's pretty broad. And when you have an employee who claims a serious health condition, you are entitled to get enough information to be able to determine whether the condition they're claiming justifies a request for leave meets the definition of inpatient care or continuing treatment, which we're going to look at in a little bit. And the way you get that information typically is through having the healthcare provider fill out a certification form. We're going to talk about that in a little bit. So another definition, if you will, of what a serious health condition is here, continuing treatment. It means ongoing medical treatment or supervision by a healthcare provider. Now, when you think of healthcare provider, obviously doctors, surgeons, things like that. But the CFRA incorporates regulations from the FMLA that identify other kinds of healthcare providers whose care qualifies a serious health condition for CFRA coverage. So your employee might be getting care from a podiatrist, a dentist, a licensed social worker, clinical social worker, a nurse practitioner. Care from any of them qualifies that serious health condition for coverage because it means they're getting care from a qualifying healthcare provider. So it's not just like an MD, for example. It could be a DO, and it can be any of these other things. And I know there's, having done some personal injury work in the past and just having all my years of employment law, I know that some employers, when they get doctor's notes from LCSWs, right, licensed clinical social workers, or from chiropractors, or from DOs, or NPs, nurse practitioners, or PAs, physician assistants, they look at those and they think, well, this isn't from a real doctor. So do we have to accept this? Now, in a personal injury situation, a work comp situation, that's kind of a different issue. But here in the CFRA situation, those people qualify as healthcare providers whose care can support a serious health condition qualifying CFRA request. So you have to keep that in mind. All right, a brief recap. As I said, I could go into continuing treatment, and there's all kinds of things that go into there, but it would take much too long. The regulations can be really helpful on that. But it's important to look at that issue. But a brief recap when you're looking at serious health condition. Is the employee unable to perform one or more essential functions? Do they have an illness, injury, impairment, or physical or mental condition that involves inpatient care as defined? Or if not that, does it involve continuing treatment? And if you check the boxes on those, then conclusion is going to be they have a qualifying serious health condition. Okay, baby bonding. Now, some people get confused because California, as you probably know, has a separate leave benefit or leave law called the pregnancy disability leave. This is when one of your employees is pregnant and her healthcare provider says that they are unable to work or need some type of accommodation with schedule or with light duty work or something like that because of a pregnancy-related disability or other pregnancy-related medical condition that makes the woman unable to perform all of the essential functions of her position in the normal, in sort of the usual sense, without accommodation. And under California law, a pregnant employee is entitled to 17 weeks of pregnancy disability leave up until the point that the baby is born or until those 17 weeks are exhausted. Once that baby is born, usually what kicks in is CFRA baby bonding time, right? So if the employee has a baby and if the doctor says that the employee continues to be disabled by childbirth, for example, and she has pregnancy disability leave remaining, she can use that until those 17 weeks are exhausted. And then she can start using the CFRA baby bonding time. The usual situation is that the mother may or may not use pregnancy disability leave, depending on whether there's complications or disabilities or whatever. They then go off work because they're going to have the baby. They have the baby, and then at that moment, their time off work will fall under baby bonding CFRA leave time, and they get 12 weeks of that. They don't have to show a serious health condition. They don't have to show any other criteria. Now, it used to be under the old CFRA that if you employ a husband and a wife, only one of them could take time off, or let me say it another way, there could be 12 weeks off between the two of them. But SB 1383 changed the CFRA starting this year such that both parents who work for you can take up to 12 weeks off for baby bonding purposes. Kind of mind-blowing, but that's the law. And it's not going to change soon. That can be really burdensome, especially on small employees, small employers. So what happens if you're faced with a request like that? Nothing prevents you from talking with the two parents, right, the two employees, to try to see if there's a way that they might be able to be agreeable to staggering their time off to reduce the burden on your business operations. You can't pressure them to do it. You can't force them to do it. And of course, you sure as heck can't penalize them in any way, shape, or form for not agreeing to do it. But it's okay to talk about it. And hopefully they'll be mindful of that and whatnot. But again, this is the law now, and you've got to abide by it. So now we're back to this qualifying exigency. And what are some of these unique activities that your employee might need time off for when they have a family member who's been called to active duty? The CFRA refers to the California Unemployment Insurance Code, section 3302.2. You can Google that if you want to have the complete and detailed list of the types of activities that count as qualifying exigencies. But I've listed the primary ones here. When they have to deal with a short notice deployment, right? They have to get their affairs in order. There's military events that the employee has to attend to, childcare issues and school-related issues and activities, financial and legal arrangements, parental care activities. There's all kinds of things that military families have to deal with when an employee or an employee family member is called to active duty and is going to be deployed. And they are allowed to use CFRA leave to have time off to do that type of thing. All right. So how do you know when one of your employee might qualify or might be asking for leave that could qualify for CFRA leave? They don't have to use CFRA or the words California Family Rights Act or anything like that. But they do have to say enough information that puts you on fair notice that they need time off for baby bonding or some serious type of medical condition or health condition. I mean, they might say, I have this health issue, I need surgery, I need a lot of time off. There's different ways it can come up, right? And they may not say the words baby bonding, but they're gonna say, look, I'm gonna want time off, my wife's having a baby, and I'm gonna wanna take time off to spend time with my family. I mean, that's baby bonding, right? They don't have to use these magic words. So when you hear the kind of words that make you think, I wonder if this is going to be CFRA leave, but you're not sure, you should, and you have every right to ask the employee for more information, right? To find out if the reason they want time off could be a CFRA qualifying reason. When an employee can predict or knows in advance they're going to be taking time off, and that's usually the case when, for example, a husband who's working for you, the wife can have a baby, right? Or the mother's working for you and she knows she's going to take time off after the baby is born. They need to give you at least 30 days advance notice of their desire and intent to take time off for baby bonding. Another situation is where an employee has advance notice of the need for time off for a serious health condition or to care for a family member with a serious health condition. And the classic example might be where they're taking time off for an ongoing treatment or a surgery, right? And that's those don't come up just overnight, right? Those are planned ahead of time in the vast majority of cases. And so when your employee is going to have a hip replacement, for example, they're going to know about that more than 30 days ahead of time in most cases. They're supposed to give you 30 days advance notice, at least as much notice as possible. Sometimes, though, things come up on a more urgent or unexpected basis. And in that situation, the employee is supposed to give you as much notice as what they call practicable, which I just think is another word for practical, basically as soon as they can, right, given what the circumstances are. So if they find out, for example, that their mother is going in for emergency surgery and something, and they have to care for the mother's husband, their father, who can't care for himself while the mother's in a hospital, that can come up pretty suddenly, for example. Then, the employee has to give notice as soon as practical about something like that. So these are the types of notice issues that you should keep an eye out for. All right, let's talk about this 12-month period, right? Employee gets 12 weeks, up to 12 weeks of time in a 12-month period. There's 4 ways to define what that 12-month period is. You can go by a calendar year or other fixed 12-month period. Like if maybe your company's fiscal year is like July 1 to June 30, that's a pretty common one. It could be anything, any fixed 12-month year. It could be what we call a forward-looking 12-month period, meaning the date that the CFRA leave begins, the next 12 months in the future are that 12-month period. But the most common way to calculate the 12-month period, and I'm going to explain why in a second, is what we call the rolling backward or looking back method, which basically says whatever day the employee begins the CFRA leave, you take that day and you look backwards at the previous 12 months. Because what you're trying to do, right, on that first day of CFRA leave that the employee is requesting, you're trying to determine how much leave do they qualify for. And you do that by determining how much leave have they had in the last 12 months, right? If on, let's say they're asking for leave to begin on January 1st of 2022, then you look back 12 previous months. And if they've taken 6 weeks of CFRA time in those previous 12 months, then as of January 1st, 2022, they are eligible to take 6 more weeks of CFRA leave. And then when let's say they take 3 weeks, now that takes them up through the end of March. Wait, that's not right. They take 3 weeks, it takes them up through the close to the end of January. Then let's say they're back at work for a couple months and now they come to you and say, I want to take more time off starting May 1st. Well, now you look back on May 1st of 2022, you look back 12 weeks and 12 months and you find out how much CFRA time have they taken off in those 12 months. And then you subtract that from 12 and that's how much they can now take going forward on May 1st. So it prevents this stacking problem because in a typical situation, if you just did it a year by year thing, you could have an employee take, say, November and December off of work for CFRA reasons, right? And then January 1st comes around, they could say, I have a fresh 12 months. And so I have a fresh 12 weeks of CFRA time. They could then take off January, February, March, and now you've lost that employee for 5 straight months. That's crazy. That's why I never recommend that type of 12-month period or even the fixed month period. I think the rolling backward one is the best way to go. Whichever one you choose, you have to stick with it and apply it in all employee situations. And you can only change it when you give 60 days notice to your employees that you're using a new 12-month calculation period. And you should explain in your employee handbook CFRA policy which 12-month calculation period you're using. As I mentioned before, an employee can ask for intermittent and even what we call reduced schedule leave, meaning instead of working 40 hours a week, they just, for whatever reason, their doctor's saying they can work 30 hours a week or 20 or whatever it is. Instead of sort of an intermittent thing. And that might be justifiable as well. So employees can do that. There's a lot of rules associated with this, including in the regulation called section 11090, subsections D and E. Those are really important in this area. It's important to keep thorough records, right, about the exact amount of leave that the employee is taking when they're on an intermittent or reduced schedule leave basis. Because on a typical one, right, they're gone for 4 or 5 weeks or whatever. That's easy. They're just, that's easy to count and keep track of. But if they're taking 4 hours here, 2 hours there, they're working, on a reduced schedule leave for the period of a couple of weeks or months, you want to keep track exactly of how many hours they are taking off work for CFRA reasons, because you want to calculate that and attribute it to the 12-week maximum and keep track of that so that as they know, they're getting close to exhausting that 12-month limit, you want to make sure they know about it and that there are plans for them to come back to work or to get off the intermittent or reduced leave schedule. A couple things on the intermittent thing I wanted to mention. I had them marked here in some paperwork. Oh, here we go. When you have an employee who wants intermittent or reduced leave schedule, they have to make a reasonable effort to schedule the treatment so as not to unfairly or what they call unduly disrupt your business operations. However, and this is important to remember, you cannot require an employee to schedule their medical appointments or military activity appointments or anything like that around your business's operational needs. You can ask for it, and they should make efforts to try to do it, but you can't require them to do that. It might be in some cases where you might have the ability to transfer an employee to a different position for the purpose of accommodating their time off for their own serious health condition, or when they're going to take time off to care for a family member's serious health condition. And those types of transfers are typically temporary, right, until their need for time off is done. And you really aren't supposed to reduce pay or anything like that. But if you need, because of operational requirements, need to get them out of a position where that position simply can't afford that time off and put them in a different position or a different schedule, you're allowed to do that. Okay, when an employee makes a request for leave that appears to be or explicitly is for leave under the California Family Rights Act, you have an obligation to respond to that request. Now, that response is supposed to come within 5 business days after the request. That response doesn't mean necessarily that you're granting the request at that point. It might be if in those 5 days you've determined that the employee is eligible for CFRA leave, has CFRA leave remaining in the applicable 12-month period, and is asking for time off for a qualifying reason, and you can have that on all 5 days, and you're not going to ask for a certification of a serious health condition, we're getting to that in a second, then you can decide that they get the CFRA leave, in which case your response can say, we're granting your request. And then as you'll see in a few moments, you're going to designate their time off as CFRA leave. What often happens, particularly so when the employee is asking for time off for their own serious health condition or to care for a family member's serious health condition, the employer has the right to ask for the employee to get their healthcare provider's certification of a serious health condition. And you have to give them a certain amount of time to do that. you put that in your response. You basically say, hey, we got your request. We're acknowledging it. You're eligible from hours standpoint, from service standpoint. We need, though, to since you're asking for time off for your serious health condition, we want the certification. You give them the certification form. You give them 15 days to get it back to you at least. And then, you kind of hold off on making a formal decision on the CFRA request. But within 5 days, you have to at least acknowledge and get back to them that you've gotten the request and that you need additional information. Once you have that information and the employee's request appears to be in order, then, and you approve it, that approval is retroactive to the day when leave first began, because you are allowed to kind of allow them time off when they need it, even before you've made a formal designation of that time off as CFRA leave. You can retroactively designate it as such in most circumstances. Let's talk about the certification issue. And here you're going to want to look at section 11097 of the applicable regulations. So here, I think certification is worth doing in most cases, but the fact is, you really get almost no helpful information. And let me explain that. So the statute and the regulations allow you to require the employee to have their healthcare provider fill out a written certification that the employee has a serious health condition. But when you look at the form, which is in the regulations, they give you sample language. All it really says, it has the doctor say, I'm seeing this employee, and I've read the definition below of what a serious health condition is. My patient has a serious health condition, and they need time off from day one to day whatever. Signed, Dr. So-and-so. And that's really about all you get. It's almost meaningless in some ways. You don't get medical diagnosis. You don't get a lot of detail about, what how the condition is affecting them, for example, why they can't do their job. So you just kind of have to remember that going in. When you, though, have an employee who is taking time off, you might have some doubts about whether they're gaming the system. I'll give you an example. I was representing a client recently that had an employee talk about having some heart issues and want to take some time off. The employee knew that the employer was unhappy about the employee's performance. And this employee, sure enough, ended up giving them a doctor's note that had nothing to do with her heart medical issues. It had to do with her feeling stress from the workplace. And so she had a psychologist put her off work for 6 or 8 weeks, something like that. And it's natural for an employer and an employment law attorney on the employer side to look at a situation like that and wonder if this is just, what's going on here, right? Is this really legitimate, right? Well, you can't just dismiss it out of hand. But what you can do is really check these boxes and send the certification form to the employee and say, look, it looks like you're asking for time off for CFRA reasons. And if that's the case for your own serious health condition, I need you to send this to your doctor and have them sign it that you have a serious health condition. And oftentimes I have found that employees who just really don't want to be back at work, or they're tired, they don't want to face their performance issues or deal with their supervisor, they don't want to come back to work, and they don't want to deal with this issue of going through the whole CFRA thing. So in the circumstance like this, pushing on the certification issue might actually end up having the employee decide to resign and not come back to work, which in many cases I found is exactly what my client employer wants to happen. And that's certainly better than firing them after they've asked for time off for medical issues, right? But don't think you're going to get a certification back from the healthcare provider that has all kinds of detailed information. Once you get it back, you pretty much have to accept it with a couple of exceptions. You can't contact a healthcare provider unless you have a valid belief that the certification might not be genuine. In other words, if you think that it was been forged, for example, or that someone just made this form up, or they can give it to their doctor and all, they just wrote it in. I don't know, I've never had that happen. And unless the employee was stupid enough to write in their own handwriting, which you have examples of from the personnel file, or to sign it in their own signature, you're probably not going to have a situation like this. But you can't just follow up the healthcare provider to say, hey, I don't understand this part. Can you clarify that? That's not allowed. You have to provide the certification and give them no less than 15 calendar days to get it back to you. And unless there's extenuating circumstances, like their healthcare provider simply is not responding, whatever, has been in surgery for weeks or days on end, who knows what, and it's really not the employee's fault, then you should give them some additional time. Otherwise, if they just simply are dragging their feet and not being responsive to you, if they haven't gotten that certification back to you in 15 days or within a few extra days, if you give them extra time, that is a basis for denying their request for CFRA leave. It doesn't mean they're going to come back to work, but what it means is that their leave is not protected by the CFRA, and you can treat it like any other sort of unexcused absence under your work policies. So let's talk about what you can do if you have some questions about the certification and its validity. You are allowed to ask the employee to undergo an examination by a physician that you designate. Of course, you have to pay for it, and you get the second opinion. And if the doctor's second opinion corroborates the employee's doctor, you probably got nowhere else to go except the certification and go on from there. If your doctor says, yeah, that's not a serious health condition, and now you have these competing opinions, right? The employee's doctor and your doctor, you can get a third opinion to break the tie, possibly. And that's only, of course, if the second opinion differs from the first opinion. You have to, that third doctor has to be jointly approved or designated by the employer and the employee. The employer pays for it, and the result of the third opinion is binding. So even if you don't like that third opinion, you're now stuck with it. I honestly have never had a client go through this process. Of course, you have the cost of paying for a second and third opinion that you have to absorb. And I've just never had an employer be so skeptical about the employee's doctor's certification that they felt it was warranted. But that procedure is there if you do have one of those unusual situations where it looks like the certification may not be valid. All right. The employee is giving you notice. You've responded within 5 days. You've asked for your additional information, if applicable. And now you've gotten everything you need to know. You see that all the boxes are checked. Now you have to designate the leave as CFRA leave. That has to be done in writing. You have to give it to the employee. And that designation has to inform the employee specifically that they have a right, they are guaranteed to be reinstated to their job, their same job or a comparable job. And you might say subject to, legal exceptions or something like that. But that's supposed to be, let me take that back a little bit. The policy that you give employees is supposed to say that. When you designate leave to the employee, you have to tell them verbally. If they ask for something in writing, the guaranteed reinstatement, you have to put it in writing. I think it's a good idea anyway to put it in writing in the designation notice. Employees are probably going to ask for it anyway. I think it shows that you are taking your duty seriously and recognizing what your obligations are under the CFRA by putting it into the designation notice. We're going to talk about those exceptions where reinstatement may not apply. All right, let's see, I got about 10 minutes, so I'm probably going to talk a little more quickly now, just because I don't want to spill over the time too much. But we only have a couple more topics to go through. One is pay. So the CFRA leave is unpaid, but you can require, or the employee may choose to use, if you don't require it, their vacation or PTO to cover some of their unpaid CFRA leave. With respect to paid sick leave, You can require an employee to use paid sick leave when their CFRA leave is for their own serious health condition, not any of the other situations. However, the employee can on their own choose to use paid sick leave to cover their CFRA leave for any of the 4 qualifying reasons. I take that back. They can choose to use paid sick leave for their own serious health condition, for paid sick leave for any of the 3 other qualifying reasons. Both the employer and the employee have to agree that the employee can use their paid sick leave. Sorry for misspeaking. A lot of times, employees can get state disability benefits for their unpaid CFRA leave, right? If their health condition is one that qualifies as a disability under those laws, they can get state disability benefits. They also can be entitled to paid family leave benefits, which is like the state disability benefits. It's administered by the EDD. It's not a leave of absence, so to speak, but it's a wage replacement benefit when an employee is taking time off work under the CFRA for baby bonding or for caring for a family member with a serious health condition. So you want to be sure you notify your employees about those benefit possibilities. All right, let's move forward. Benefits is another issue that you have to be mindful of. The general rule is this: you have to continue during the CFRA leave the employee's healthcare benefits at the same level and under the same conditions as if the employee was not on leave at all. So the typical scenario, of course, is that you're deducting premiums from the employee's pay, and you, the company, are paying your own share of the premiums. Well, during the leave of absence, that can continue and has to continue if that's what the employee wants. If they're getting paid leave through vacation or PTO, for example, you can continue to deduct their premiums from that paid leave. But if there's unpaid leave, you can require the employee to pay you on their own, whether it's through a check, through some online payment, whatever, on whatever basis you want. It's usually monthly. You tell them, hey, get me a check for X amount of dollars for your share of the premium. And of course, you're going to pay your share and keep their coverage in play. So that's important, and you want to be sure they know about that and make it very clear to them what they have to do to get you their premium so they can keep that coverage in play. Now, the benefits continue until the CFRA leave is exhausted. If the employee doesn't come back or they're laid off and their leave is legally ended because of a valid layoff, then the benefits obviously are going to stop. If the employee has not been paying their premiums, there are circumstances where you can get those paid, at least have a right to get them paid. Whether you want to go through trouble or not, if they won't do it voluntarily, is a different issue. But let's talk about that for a second. So if the employee is late with premium payments, you can cease their benefits coverage. When an employee has failed to pay the premiums they're supposed to pay, then you can recover those from the employee in those 2 situations at the bottom 2 sub-bullet points there. If they failed to return from leave when they're supposed to, and by the way, if they come back from leave but work for you less than 30 days, that is considered to be a failure to return from leave. If they've worked more than 30 days, then they are considered to have returned from leave. So if they haven't returned from leave and it's for a reason other than a continuance or recurrence of their health condition, then you can recoup those unpaid premiums from them. Hopefully they'll pay it voluntarily. If not, you might have to resort to a small claim action. All right, let's talk about reinstatement. This is what drives small employers bananas, because think about it. You're a 2 or 3 or 4 or 5 person company. Let me take that back. You're a 5 or 6 or 7 or 8 person company, and you now are losing somebody for 12 weeks, maybe 1/5 or 1/4 or even 1/3 of your workforce, depending on how many you have. So that can be really burdensome. And so when they hear they have to reinstate somebody who's been out for 12 weeks, like, what are you going to do in those 12 weeks? Everybody else is going to pitch in and work a bunch of overtime? Or are you going to be able to find somebody who's going to be agreeable to this working for 12 weeks until your permanent employee comes back? That might be difficult to do, but that's what the law is. As I said, you have to inform the employee that they are guaranteed reinstatement. Even if you do replace them, or if you've somehow restructured your operations or their position to accommodate their absence, you have to bring them back. If the employee is no longer qualified for their position because of training that became necessary, they don't have, or they had to renew a license and didn't have a chance to do that while they were on leave, you have to give them a chance to get that training or renew that license, or whatever the case may be, in order to have the opportunity to be able to fulfill the requirements of the position that they're returning to. If the same position is not available, you have to look at getting them a comparable position, which is one that's virtually identical in terms of pay, duty, shift, schedule, geographic location, things like that. Can you or should you require a return to work release? That's really common in things like the work comp arena and just somebody who's out for an extended period of time, disability accommodation scenarios. You can require it. And I think in most cases, it's a good thing to do. But you got to tell the employee before the leave begins that you're going to require them to have that medical release for return to work, right? Make it part of your written policy that you give them and make it part of what's in your employee handbook. You can only require a return to work release for a CFRA employee, though, if you have a similar requirement for other types of leave within your company. So don't make it specific just to CFRA leave. Now, for intermittent or reduced schedule leave, the rules are a bit different. You can't ask for a release every time they come back from an intermittent leave, for example. However, you can require a return to work release for absences once every 30 days if you have legitimate safety concerns about the employee's ability to perform their duties. You just have to be real careful about that. Again, these are explained in more detail in the regulations. What you can't do for an employee who's out for a serious health condition under the CFRA is require them to take a fitness for duty examination. It's not allowed. Once they're back, any fitness for duty exam you have them do has to be job related and consistent with business necessity, and usually has to be done with respect to similarly situated employees as well. So you have to be real careful about those. All right, reinstatement. When is it not required? If the employee would have lost their hours or their job, even if they weren't on leave, then they can lose their hours or their job while they're on CFRA leave. So that's a pretty heavy burden, though. You're gonna, if you, for example, eliminate the employee's position while they're on CFRA leave, your defense when they sue you is going to be, we would have eliminated that position, even if they weren't on CFRA leave. And that's fine. Maybe that's true. But for it to be a successful defense, you have to not just be able to say it's true. You have to be able to prove that it's true. So you better have documentation of some kind about your deliberations and why you chose that position and what the financial hardship your company was going through at the time that led to the decision to eliminate one of your positions. And what is your plan for having that position's duties performed by your remaining employees? All of that stuff needs to be in writing, contemporaneous with the time that you make that decision, if you want to have good leverage to oppose an employee's claim that you retaliated against them or interfered with their CFRA rights. We're going to talk about that in a second as we wrap up this webinar. You'll see at the bottom of this screen, there used to be in the CFRA until this year, a defense that said, if the employee is considered to be a key employee, you were not required to guarantee reinstatement, because losing a key employee for 12 weeks could be, completely burdensome and unduly burdensome for most employers. But that defense isn't available anymore. You have to give all employees, no matter how important they are, and even when they take 12 weeks off, the right to come back to work. All right, the CFRA requires various kinds of notice. If you don't have it already, those workplace posters that you probably subscribe and get every year, you have to make sure they have the new CFRA language. If you haven't done that yet, that should probably be number one on your priority list. Make sure you have that in your workplace. You can get an example one specific to the CFRA by Googling the DFEH CFRA required poster. Give the written policy to your employees. I strongly recommend that you develop a CFRA policy. I do these pretty frequently. It's not long, but it's just like something you would put in your handbook, but it's a standalone document. Get it out to your employees if they don't have something like that already. And the next time you update your employee handbook, put that CFRA policy into it. You don't have to update your handbook specifically for that policy right now, but next time you do it, make it an addendum or revise the handbook to include that CFRA policy. I think that's a great way to show that you've given notice to your employees. If 10% or more of your workforce is non-English speaking as your primary language, you have to ensure that you've given notice in that other language. And the regulation here, 11095, has some good information about the notice requirements. All right, just a couple more minutes. I'm sorry to keep you over one. The reason this is so important, ladies and gentlemen, is because of the potential legal exposure if you don't get this right. There's two basic types of claims: an interference claim and a retaliation claim. Interference is when you wrongfully refuse to authorize or designate CFRA leave, when you discourage an employee from taking CFRA leave, or when you avoid or fail in your obligations under the CFRA. And I've given you a couple examples there. Another way is through retaliation. There's basically two retaliation protections. One is what we call protected activity, and that means when an employee has asked for or otherwise exercised their right to take leave under the CFRA. It also includes when an employee gives information or support or testimony about their CFRA leave or about another employee's request for CFRA leave. They are engaging in protected activity and are protected from retaliatory conduct by the employer for supporting another employee's request for CFRA leave. Prohibited acts is another kind of retaliation protection, and that means when the employer does things they're not supposed to do under the CFRA. Like you're not providing the same benefits to an employee who's on unpaid CFRA leave as are provided to employees on other types of leave. Using their taking of CFRA leave as a negative factor in making employment decisions or a performance evaluation. Counting their CFRA leave against them under your attendance policy. You can't do that. Or just flatly firing them because they took time off under the CFRA. Those are like automatic lawsuits. Just don't do it. All right, a couple more slides. The new bill, SB 1383, implemented this new mediation pilot program, which is specific to companies who employ 5 to 19 employees. And after you get a right to sue letter that's supposed to be served by the employee's attorney or the employee, they've gotten from the Department of Fair Employment and Housing their written authorization to file a lawsuit for violation of the CFRA. That written authorization is supposed to be served on you as the employer. If you have 5 to 19 employees, you have the right, once you get that notice, to contact the Department of Fair Employment and Housing and say, hey, I want to do your mediation pilot program for small companies. At that point, the DFEH gets involved and sets up a mediation to see if it can resolve this lawsuit between you and your former employee about alleged violation of the CFRA. And until that mediation takes place, the employee is not allowed to file a lawsuit against you in court. I haven't seen this used yet. I haven't been involved in one yet. I think the DFEH really likes to settle disputes like this. So if you find yourself in this position, I think I'd recommend you at least explore it, right? It's not binding, right? You can go to it, and if you just can't get it settled, you can't get it settled. You can deal with it from there. But it's inexpensive, and it's probably a good way to try to avoid further legal action. All right, folks, here's your takeaway items. As I said before, you got to have posters. Do your handbook addendum, and then at the appropriate time, update your handbook to include a specific CFRA policy. Develop a process for handling CFR requests. Who in your company is going to take the request? Who's going to evaluate it? Who's going to respond to it? Have a protocol sheet written out so you know exactly what to do, kind of a checklist of things. I'd be happy to help you with something like that. Create documents, create a leave request form, create a response form, create a designation notice, create a template certification form that you're going to use, create the cover letter for the certification form that you can give to your employee. Make it as easy for them as possible. And you're making it easy for yourself by getting these forms ahead of time. You'll have a little bank of them that you can use every time you have a request. Train your managers and their supervisors. So, I mean, the people who are acting as your agents need to know what the CFRA is. Maybe not as much detail as you do, but they have to know how to identify an employee's request for CFRA leave. They have to know what to do when they get that information, right? If you want them to direct it to your HR person, your CFO, your CEO, your owner, whatever it is, give them a specific direction as to what they're supposed to do. And have them avoid things that might be construed as comments that discourage employees from taking leave, right? Like, oh man, I can't believe you're going to be out this long. It's going to be such a pain for us, and something like that. I mean, I hear about this stuff pretty often. Those kinds of little nuggets of information create leverage for employees in lawsuits. And you want to make sure your managers avoid saying things like that. Hold them accountable. Communicate often with the employee as reasonably as necessary. Nothing's better in these types of things than have good, solid communication with the employee, so there's no questions about what they're doing, what you're doing, what's expected from each side. Document, document, document. That's a lawyer's favorite term. Also, make sure that when you are doing a performance evaluation, considering raises, bonuses, schedule request changes, PTO time off, vacation time off, promotions, anything like that, don't take into consideration the fact that the employee at issue took CFRA leave. If that's a consideration at all, you're really opening yourself up to potential legal liability. And last but not least, consult with an employment law attorney. In most of these cases, they're really dicey, and you really don't want to make decisions about an employee's employment status when they've asked for or are on or have just come back from CFRA leave. It can be really tricky. So that's what I have for you on our crash course with compliance with CFRA leave. Does anybody have any questions? And if you don't now, I'm happy to answer anything later. You can drop me an email.